This lecture highlights some of the matters that are discussed in Chapter 9 of the textbook, which deals with criminal procedure. The introduction to the chapter contains an excellent discussion of the many issues that are involved in criminal procedure, including such issues as how can a criminal defense lawyers represent defendants that they know are guilty. And the quote on the first slide, it is better that 10 guilty persons escape than one innocent person suffer. And that quote from William Blackstone really is an excellent summary of the nature of the American criminal justice system, and the fact that we do extend protections to criminal defendants with the idea that we do not want innocent people to suffer, and therefore we afford protections to people that might result in the guilty persons actually getting off. One of the things I want you to keep in mind is that in talking about criminal law, we continue to focus on harms to society as opposed to harms to individuals. And even though crimes generally do consist of harms to individual, in criminal law, we focus on the fact that criminal behavior is defined by the legislature, what acts are criminal and what acts are not. And again, remember that crimes can be prosecuted by the government, even though the victim of the crime may not want prosecution to go forward. Again, illustrating the fact that crimes are offenses against society. Criminal procedure deals with the process from arrest through trial. And again, the basic structure of our criminal procedure system is that we have this process in place to protect people from unjust prosecutions. Criminal procedure involves court rules that have been adopted by the various court systems, whether they're state or federal, as to how criminal proceedings are conducted once they reach the court system. And in addition, we have rules of evidence that govern the admissibility of evidence in courts of law. The various stages of the criminal procedures are summarized in figure 9.1 at page 243 of the textbook with its flow chart. One of the things I do want to emphasize is that the actual procedures vary from state to state. For example, some states do use the grand jury system, some states do not. So again, criminal law, at least at the state level, can vary widely from state to state, and it's important to make sure that we know exactly what the laws of the particular state are involved. One thing that is common among all states and the federal system is that due process of law is required. So whatever the various state procedures may be, the overriding constitutional requirement that criminal defendants be afforded due process of law must be present. All right. There are various participants in the process of the criminal justice system. Again, as I said, the victims are the people that are typically suffer from the criminal conduct, although there are crimes that we consider to be victimless crimes, such as prostitution, drug abuse, etc. But again, the victims are obviously a main part of the criminal justice system. Law enforcement is, of course, intimately involved in the criminal justice systems, and whether or not they are investigating officers or actually witnesses to the crimes itself. Attorneys are, of course, a very important part of the criminal justice system, and the paralegals that work with attorneys. One thing I wanted to emphasize here is the role of the criminal defense lawyer. One of the ethical requirements of all lawyers is that they are not allowed to mislead the court. So an attorney can be disciplined and indeed disbarred if they make arguments to the court that the attorney knows to be false. So how does this apply in criminal law? Well, oftentimes criminal defendants will confess to their lawyers that, yeah, they are in fact guilty of the crime charged, and what they're seeking is the least possible sentence. So how can an attorney in that situation deal with the court system and the prosecutor's office? This doesn't mean that the attorney cannot try the case and try to and make every attempt to get their client off completely. Remember, the result of a criminal trial is either the defendant is guilty or not guilty. Not guilty does not mean innocent. It just means that the prosecution has failed to meet its burden of proof. And again, the burden of proof in a criminal matter is that the prosecution must prove the guilt beyond a reasonable doubt. So a defense lawyer in a situation where they know that their client is guilty will not argue to the court or to the jury that their client didn't do it. Again, that would be an ethical violation. Instead, what they argue is that the prosecution did not meet their burden of proof. And it's perfectly acceptable for a criminal defense lawyer to attack the prosecution's proof and attempt to dissuade a conviction. Many of you, most of you aren't old enough, but if you look back in your history books and you look at the O.J. Simpson trial, O.J. Simpson had, of course, this all-star team of defense lawyers led by Johnnie Cochran. What many people don't know is Johnnie Cochran was actually a prosecutor for decades before he became a criminal defense lawyer. And his famous quote during the trial, one of the famous quotes, it had to do with a glove that didn't fit on Mr. Simpson's hand. He was alleged to have worn this glove in committing the crime. Well, we now know the reason the glove didn't fit on this hand is because it had been soaked in blood and what have you, and it had shrunk. So it could no longer fit in his hand. But Mr. Cochran argued to the jury, if it doesn't fit, you must acquit. That's a far different statement from saying that Mr. Simpson did not commit the crime. And none of O.J. Simpson's attorneys ever argued that he didn't do it. Instead, their defense was focused on the prosecution's case, and they were able to successfully argue to the jury that the prosecution had not met its burden of proof. Interestingly, there was a civil trial for wrongful death that followed on the heels of the criminal trial. And again, same facts, obviously different lawyers that were involved, but in that civil trial for wrongful death that was brought by Ronald Goldman's parents, they were able to obtain a plaintiff's verdict against Mr. Simpson, essentially having two contrasting opposite verdicts in the criminal trial versus the civil trial. Again, in the civil trial, the burden of proof is preponderance of the evidence as opposed to beyond a reasonable doubt. So again, keep those ethical issues in mind. There's a good discussion of the entire criminal process and the investigation proceeding in the textbook. I'm not going to go over it in great detail, including how crimes are investigated. There are constitutional restrictions in the criminal justice system. These are outlined in our Bill of Rights, the 4th, 5th, and 6th Amendments to the Constitution that afford various protections to criminal defendants. Amongst these protections is the prohibition against unreasonable searches and seizures, and this is contained in the 4th Amendment. And in evaluating whether or not a search and seizure is reasonable, the courts will evaluate a defendant's reasonable expectation of privacy. This gives rise to the doctrine that things that are in plain view, there are no expectations of privacy. So if an officer pulls over somebody for a traffic violation, and they look in the and they come up to the driver's door, and they look in there and they see contraband, illegal substances, firearms, what have you. Again, no warrant is required to make a search for that. It is in the plain view. When search warrants are required, a search warrant is something that's issued by a judge, and upon the application of the police department. And oftentimes we have paralegals that are actually employees of the police department that will be involved in preparing the applications for the search warrant and processing that through the court system. Again, coming back to the plain view requirement, again, we still talk about reasonable expectations of privacy. So I gave you the one example of something appearing in somebody's vehicle. You can contrast that with perhaps somebody has maybe they have illegal activities going on in their backyard. Perhaps it's growing excessive amounts of marijuana or what have you. Question is, what is a reasonable expectation of privacy in somebody's backyard? Does this permit the police to jump over the fence and look into it? Probably not. What about, does this allow for the police to fly a drone over somebody's house? Do we have reasonable expectations of privacy? So these are issues that criminal defense lawyers deal with, and there are some good discussion questions at page 249 of the textbook regarding our expectation of privacy. Again, there are many types of searches that can be made without a warrant. In addition to the plain view doctrine, again, people can consent to a search. There's nothing that presents that. Again, we can look at page 248 of the textbook, figure 9.2, to see a detailed summary of circumstances when searches can be made without a warrant. One of the current hot topics in search warrants and warrant and when they can be dispensed with is in the area of DNA and DNA that's in the public. This was first, or the most prominent example of this was a serial killer whose crimes had gone unsolved back in the 1980s and 70s. The DNA had been left at the scene of the crime, but they weren't able to match it up with anybody in the system. An FBI lawyer and investigator from the Contra Costa County in California contacted one of these commercial DNA genealogy websites, DNA websites, and this one was GED Match, which allowed the FBI to access its database. where they found several matches of individuals who turned out to be distant relatives of the criminal that had left the DNA. They cross-referenced these, and they were eventually able to match up that DNA with one individual, and that in 2018, the individual suspect was arrested and eventually convicted based upon that search and that evidence. One of the ways that they actually collected DNA from the individuals, they put him under surveillance, and were able to retrieve, I think it was a coffee cup or something that he had discarded, and they were able to get his DNA off that coffee cup, compared it to the DNA that left at the crime scene, and boom, there was a match and a conviction. So people have argued that we should have some reasonable expectation of privacy with respect to our DNA, and those arguments have really gone, I think, nowhere in the court system. All right, Miranda warnings are discussed at length in the textbook, and these arise out of the Fifth Amendment right against self-incrimination, and the Sixth Amendment right to an assistance of counsel. And again, there's a good discussion in the textbook about that. And keep in mind that a Miranda warning is only required if someone is in police custody. It applies to what we call custodial interrogations. So the question always is when does somebody transition from being a suspect to being in custody of the police? And the courts apply a subjective test to that, and it simply means that somebody is in custody when they believe that their liberty has been deprived in some fashion. Right. Once an arrest is made, an arrest must be made upon probable cause, and we can have arrest warrants issued by the court, or we can have a law enforcement officer make an arrest if they have the officer has probable cause to believe the person being arrested has committed a crime. And this could arise from many sources, including the officer witnessing the crime, or perhaps interviewing witnesses, giving rise to probable cause. Bail is a part of our criminal justice system. As many may know, bail is designed to make sure that a defendant appears in court. A defendant may be released after they've been arrested on bail, but they have to post that. And if they can't post it, they remain in custody. If they do post it and don't show up, the bail is forfeited to the government. Bail is typically posted by bail bondsmen who charge a fee for their service. My understanding is generally about 10% of the amount of the bail. And a bail bondsman will almost always require some kind of collateral for the bond. So a bail bondsman isn't just going to trust their customers' promise that they're going to show up in court. Again, if the customer skips, the bail bond posted by the bondsman will be forfeited. So good bail bondsman will require collateral for the bond. It could be a cash collateral posted by a relative or something, or it could be a deed of trust on real estate, pink slip on a car, etc. Bail is a very controversial topic right now in the criminal justice system, and in many instances, states and jurisdictions have greatly reduced the amount of crimes that bail has been required for, and they use the term cashless bail, where people are able to get out essentially on their own recognition. And again, this has become very, very controversial, where we have situations of repeat offenders who are released without a bail and then can commit further crimes. The text discusses the process of bringing a case to trial once an arrest has been made. And it can be done in several different ways. In the federal system, we have a grand jury system where a group of normal people who've been impaneled as a grand jury, its function is to determine if there's probable cause to believe a crime has been committed, and therefore returning a grand jury indictment. Where in places where we do not have a grand jury system, or where the grand jury system is optional, the prosecutor files what's called an information, and that is the actual process of starting the case within the criminal justice system. Whether it's a grand jury indictment or an information, eventually an arraignment is made to the court. At that time, the defendant is formally charged of the crimes against them and enters a plea. Many of you may have seen former President Trump's arraignment on New York State charges. And again, President Trump, like any other criminal defendant, was required to appear in court, had the charges read against him, and enter his plea. One of the things that makes our criminal justice, the American criminal justice system, different from most other criminal justice systems throughout the world is the exclusionary rule. And this is a rule that's designed to prevent police misconduct. And with the exclusionary rule says if evidence is obtained unlawfully in violation of the individual's constitutional rights, it cannot be used against that individual in a trial. And there are several instances where this could happen if evidence was unlawfully obtained without a warrant, or a confession was made without Miranda rights, then that evidence cannot be used in court. The exclusionary rule has been extended to provide that any evidence that is derived from illegally obtained evidence cannot be used. And we call that the fruit of the poisonous tree doctrine. So if the tree, that's the primary evidence, was poisoned by illegal search, then all the fruit, any additional evidence discovered as a result of the primary evidence, must be excluded. So if a government illegally seized, for instance, a computer hard drive, and as a result of that computer hard drive, they obtained all kinds of evidence implicating the defendant or others in criminal activity, if it's determined that the original seizure of the hard drive was wrongful, all of that evidence derived from that cannot be used. This is a very controversial rule because it obviously can lead to either a dismissal or an acquittal of somebody that's clearly guilty. And we have, there's a controversy in society as how far this rule should be extended. And we see occasionally chipping away at the Miranda rule, for instance, what circumstances Miranda warnings must be given, but there's never been any indication that the Supreme Court is willing to go forward and eliminate the exclusionary rule. Again, this is part of our criminal justice system that seems to be very well established. A criminal trial, the thing to keep in mind, again, as I said before, it's the prosecution's requirement to prove the defendant guilty beyond a reasonable doubt. So we don't have a situation where the defendant is required to prove themselves innocent. Again, it's the prosecution's job to prove their case beyond a reasonable doubt. Keep in mind that reasonable doubt does not mean all doubt. Again, there's never a situation where you could be completely free of doubt. I'm pretty certain that the sun is going to rise tomorrow, and it's going to rise in the east and set in the west. Again, you can't have any reasonable doubt about that. I guess you could have some doubt. I mean, I guess the Earth could stop rotating, in which case, the sun wouldn't rise. Is that doubt reasonable? No, it's not. So when you hear prosecutors give closing arguments in court, they're oftentimes focusing on what is reasonable and what is not reasonable. Again, this is still a major difference from civil trial, where the plaintiff must prove its case beyond a preponderance of the evidence. So if we had scales of justice, and civil lawyers often use this metaphor that if you have scales of justice, one side just has to be tipped ever so slightly, and that is a preponderance of the evidence. Again, 51% to 49%, that's a preponderance of the evidence. Again, reasonable doubt, if we were going on percentages, certainly 51, 49, there would be reasonable doubt. I can't give you an exact formula or percentages where we reach the beyond a reasonable doubt standard, but you get the idea. The textbook continues with a discussion of the various post-trial types of procedures that are available to criminal defendants, and I leave that to your own reading. I hope you found this helpful, and again, make sure that you do review the materials in the textbook very, very carefully.